Got some major news for you to start your day. For what might just be the first time in American history, the United States Department of Justice has stepped directly into a Second Amendment case challenging an assault weapon ban in Illinois. Assistant Attorney General Harmeet Dhillon, the Department of Justice's top civil rights official under President Trump, will be in a courtroom today to argue against Illinois' gun ban in the Heller v. Bruen case. This Illinois assault weapon ban case the ban is on the line. And Assistant AG Dhillon says that the ban tramples the Second Amendment. What's up, everybody? This is Jared over at Guns and Gadgets, your go-to source for hard-hitting Second Amendment news. If you believe that shall not be infringed means exactly what it says, then hit that like button right now, subscribe to the channel if you are new, and let's break down a major turning point for gun rights in Illinois and potentially the entire country. Today, Illinois' sweeping ban on so-called assault weapons is being challenged in court, not just by gun rights groups, but now the Department of Justice, under Assistant General Harmeet Dhillon, has stepped in to argue against the ban. Now that's historic, it's unprecedented. And let me walk you through the case, the arguments, the stakes, and what this could mean for those of us who believe in the Constitution, not restrictions. Before I dive into the facts, I want to thank the sponsor of today's video, Checkmate Mags. Whether it's for competition or defense, Checkmate has been making reliable American-made magazines for over 4 decades. With their expertise in high-quality manufacturing and a never-satisfied approach to innovation and refinement, Checkmate is the leading provider of high-quality aftermarket and OEM Freedom C loaders for many makes and models. Each Checkmate mag is 100% developed and manufactured in the United States of America and is backed by a lifetime factory warranty to ensure superior performance, reliability, quality, fit and finish, everything for your favorite firearm. Thank you to Checkmate for being the sponsor of this video and support a company that supports your rights. There's a link down below. Now, Illinois passed a law that was signed by big old Governor J.B. Pritzker that bans common semi-automatic firearms and standard capacity magazines. And these are not rare or specialized military-only weapons. They are guns that millions of Americans own and use for lawful purposes, to include, but not limited to, home defense, sport shooting, hunting, etc. This isn't a fringe issue. Now, gun right groups here, led by ISRA, the Illinois State Rifle Association, among others, have long argued that this ban is unconstitutional under precedents like District of Columbia versus Heller and New York State Rifle and Pistol Association versus Bruen. Now, those Supreme Court cases made it crystal clear that the government cannot ban commonly owned arms simply because some define them as assault weapons. Now, for years, Illinois Democrats have passed gun laws punishing law-abiding citizens while failing to hold criminals accountable. Regional confusion and legal challenges have ensued. Now, here's where it gets game-changing. For perhaps the first time ever, the U.S. Department of Justice Civil Rights Division, under Assistant Attorney General Harmeet Dhillon, has intervened directly in a Second Amendment case at the appellate level. This is at the U.S. Court of Appeals. Not just filing an amicus brief, they did that in June, but Dhillon here has been granted time to personally argue in the 7th U.S. Circuit Court of Appeals in Chicago. Her amicus brief already declared that Illinois' ban on commonly owned firearms is unconstitutional. Now, she's not just supporting from the sidelines with an amicus brief, she's stepping into the courtroom to advocate for the rights of law-abiding citizens. This is huge. This has never happened before. Dhillon has even made strong public statements. She said, quote, "The Second Amendment is not a second-class right. See you in court, Illinois," end quote. That's not just rhetoric, that's a warning. And the DOJ is signaling, at least here under Dhillon, that federal constitutional rights matter and are worth enforcing against overreaching state bans. Now let's dig into the legal foundation here. Under the Heller decision in 2008, the Supreme Court said that the Second Amendment protects an individual's right to possess a firearm unconnected with service in a militia and to use that arm for traditionally lawful purposes, such as self-defense in the home. Now, bans on commonly used arms were disallowed. Then in Bruen in 2022, the Supreme Court reinforced that laws regulating firearms must be consistent with the historical tradition of firearm regulation in America. If a law bans arms that are commonly used and doesn't have strong historical precedent, it likely fails under Bruen. Now, Illinois' ban is being challenged under these exact principles. The DOJ's position here is the ban is an affront to both Heller and Bruen. It criminalizes law-abiding citizens' access to arms that the Supreme Court has said are protected. Now, standard capacity magazines, semi-automatic rifles, stuff that many people own, many need for defense or sport, etc., cannot be justly banned. Also, there's precedent in terms of how courts have struck down laws targeting commonly owned firearms without significant historical analogs. That will be a crucial piece of the argument here. Now, why should you care beyond Illinois? Because this case could set a precedent, and there are many states that have assault weapon bans and magazine bans. If the Seventh Circuit here strikes the ban down, then other states with similar bans or proposals, think California, New York, New Jersey, Massachusetts, all of them, I know there's more, they all could be next. Now, gun control proponents often look at what other states do and think, well, if Illinois can ban AR-style rifles, then so can we. This case could stop that chain reaction immediately. It also shows what federal engagement could look like when the executive branch agrees that constitutional rights are not optional. Until now, DOJ often sat out or even defended infringements. But this DOJ is stepping in for gun owners on this case, and that's huge. It gives hope that constitutional rights might get more consistent defense in federal courts. By DOJ, that could be huge. Now, there's also the deterrent effect here. State legislatures considering bans might think twice if they believe that the courts will overturn them or if the Department of Justice will argue against them. And now that includes not just state courts and plaintiffs, but the federal government itself. Makes the risks higher for overreaching lawmakers. Now, what are the possible rulings in this case? I know you're saying, what's going to happen? Well, number one, the Seventh Circuit could strike down the ban in full, and that would be the best outcome for us. It would mean that Illinois cannot enforce the ban, and similar bans elsewhere are on shaky ground. Number two is a partial strike or narrowing here in the case, and the court might uphold some parts of the ban and strike down others. Maybe standard capacity magazine bans are struck down or definitions changed. Now, definitions are at the federal level, so we'll see how that holds. Number three is they could uphold the ban. It's less likely given precedents, but it's possible depending on how sympathetic the panel is and how they interpret historical tradition under Bruen. Remember what just happened in New York I told you about yesterday? It's crazy how some of these courts think that they're advocates for what their feelings are. They're just supposed to be impartial. Now, if the decision is favorable, it could go back to act as a model for other circuits, that whole split circuit thing. If unfavorable, it could be appealed to the Supreme Court. It probably will be appealed to the Supreme Court. But every case builds precedent here. Also, watch the arguments the Department of Justice puts forward live. I mean, how they respond to counter arguments about public safety and precedent, or whether assault weapons are categorically more dangerous, which is the state of Illinois' argument here, and whether exemptions or regulatory regimes might survive constitutional scrutiny. Now, some will say these are weapons of war, and states can ban them to reduce mass shootings. And to that, I say, if they are commonly owned and they are legally used, banning them violates the plain text of the Constitution. Also, criminals aren't going to follow any bans. Law-abiding citizens are the ones being punished. Empirical evidence on whether assault weapon bans meaningfully reduce crime is mixed at best, often undercut by enforcement exceptions, etc. Now, others will bring up public safety or militia arguments, and the history is complicated there, but the Supreme Court in Heller rejected the idea that only militia-issued firearms are protected. It said that individuals have rights. Any law that broadly bans arms simply because they are semi-automatic or have a standard magazine just because someone claims they're dangerous without strong historical precedent is on weak constitutional ground. So what do we do? Well, first, you need to stay informed, because most people probably didn't know that this was happening today. which is why I'm doing a video about it. So subscribe to the channel to stay in the know. I'll keep you in the know. Cases like Harrell versus Raul matter for every gun owner, not just those in Illinois, which is why this is huge. Second, get involved. Support the groups that are fighting for you. If it's a state case, support your state groups. Support the national groups. Support all the organizations litigating these cases. Support litigation funds. Skip a pizza this month and send that $20 to $25 to your favorite group. Voice your opinion to your state legislators. Constitutional rights guys and gals are non-negotiable, and they need to hear that constantly. And third, spread the word. Use social media and tell people, this isn't about politics. This is about what the Constitution says. Use this case to push back hard against gun control as an idea. Now, before I sign off, this Department of Justice involvement under Harmeet Dhillon is unprecedented, like I said, and it's huge. And it's a resounding message that the Second Amendment is not a second-class right. I can't wait to hear what she says today. But we the people designed it so that our rights cannot be trampled simply by legislative majorities. Now, this could mark the beginning of a shift back towards constitutional fidelity. If you appreciated this breakdown, and I hope you did, smash that like button, subscribe to this channel if you haven't already, and ring the bell so that you don't miss legal updates, and drop a comment. What do you think the Seventh Circuit will do in this case? Better yet, what would you argue if you were in the court? Guys, I'm Jared. This is Guns and Gadgets. Stay safe, stay armed, stay free. Take care, America.